it's of a nature that amounts to an abuse of office. An abuse of office invokes personal liability. It invokes personal liability, and that's what they call the misfeasance of public office. You have a duty to make laws. You cannot mislead officials to say a CFO of one department has the power to make procurement for everybody. Decentralization of powers in Gauteng Department of Health. The Premier must establish in evidence that it's a lawful delegation of powers. Because that's what Ms. Lehloenya relied upon as a basis to do procurement. All the payments were made in exercise of that. And that is a different liability to say, acting, if the Premier acted within his powers, intra vires, he will, of course, be officially responsible for the legality. But if it is illegal, milady, it goes beyond that. And paragraph 38 of Annexure A in 051 to 25. Milady says these are the requirements for that delit of misfeasance, that misfeasance of public office. So then say the first third party holds a public office, he holds the public a duty, he must come and deny that he doesn't hold the duty. He breached that duty by making that law. He caused the damage. He breached with the intention of causing the plaintiff also, and the knowledge of acting in excess of his powers. So he's personally liable. That's the basis.
I'll hear Mr. Manaige on that point, because he argued with reference to different allegations. Do you have another point to make?
Yes. I do, my lady. My lady, the critical points to be made is that when it comes to claim E in the third party notice, state enrichment, we can argue about it, but nobody can recover twice for the same loss or damage. What the SIU has not pleaded in its particulars of claim. I mean, we can go back to the particulars of claim. Is that we received goods. After we brought all these actions, we went to the 6th third party and the 7th third party. We even got a final order where assets were frozen, where funds were frozen. They were forfeited to the state. It is the same basis upon which you have now brought claim against the first and second defendant. Now, my lady, SIU, that is not their case, that they have recovered so much. And that so much must go into diminution. If we allow this to stand as it is, and the state must come, we then say that under paragraph 3940, that assets have been received, funds have been received. The first defendant has not been enriched. It's important to make that point. Nobody has accused her of corruption. Nobody has accused her of fraud. There's no criminal case against her. On what basis would you then want to recover beyond your actual loss? So hence we have to plead it deliberately and to make it as a claim so that whatever the state would have received must be factored into any loss or damage which the SIU is entitled to in terms of the SIU Act.
Yeah, but isn't that a defense that she's pleaded in relation to the plaintiff's claim? That goes to the root of the extent of the alleged damages, right?
Milady, it is...
At the end of the day, as you've correctly pointed out, to the extent that the SIU has recovered from Letla, it will recover from Bidika in the pending action against Bidika. To the extent that it has received value, it's not entitled to the same value again. So it must prove its loss. And its loss is pleaded. Its loss arises largely from the exaggerated pricing. It is pleaded. It arises from the exaggerated pricing. But even more importantly, isn't this relief based on justified enrichment? Does it not avail to the sixth third party and the seventh third party, as pointed out in paragraph 41 of the third party notice?
Milady, it is not a claim against the sixth and seventh third parties.
No. I'm saying, is it not a claim that is available to them? Because I don't understand Lehloenya's entitlement to this claim under these circumstances.
Milady,
because the SIU must prove, as I've indicated, must prove the loss to the Department of Health.
Milady, the SIU did not receive the benefit. It is the state that received the benefit.
Yes, but remember, in this action, even though it is suing, it's in its name and in its own right, the SIU steps into the shoes of the department. So it is not entitled to any right that the department does not have as the plaintiff, right? So we can, for the purpose of this argument, we can accept that the SIU has received the goods.
Well,
and then pleaded, and the basis for the loss is pleaded. It is entirely different.
Milady, SIU Act allows the SIU to initiate, to bring proceeding in its own name, which a state entity could bring. And yes. SIU, in this case, for instance, has joined the MEC, even though no relief is claimed against the MEC.
Yes.
In this case.
Yes.
So it then says that the fact of it being able to litigate in the name of the state does not mean all the defenses that one could raise against a plaintiff are available to a defendant. They are not.
They are. There's actually a SCA authority to that effect. I've just forgotten the name of that authority. There is SCA authority to the effect that the SIU is not entitled to any relief that the department where the cause of action arose is entitled to. So in this case, the SIU is not entitled to any relief that the Department of Health is not entitled to. And it's going to have to prove its damages.
Maybe if perhaps just to look through the edge of argument, just to address Mr. Berger's points before I step off that point. The first leg of whether the plaintiff's claim is contractual. I've made reference to, I made reference to the Traba case. And just to say that without belaboring the matter further, I made reference to Lillicrap for the reason that, and respectfully, the confusion that was created by Lillicrap judgment and how it has been cleared in the later judgments. I made reference to it so that we do not box ourselves into this paradigm which suggests that, only if you have two possible courses of action, it must be one and not the other. It's a myth that has long been debunked. And I made reference to, I just want to go to that point. So those cases, I do not want to read those, but Milady must have regard to the claim of this SIU and whether it is entirely contractual. Hence, I said, in terms of the Basic Conditions of Employment Act, the Labour Court has dealt with the same question to say, when an employer sues an employee, is it contractual?
Please don't repeat your argument, Mr. Ogurundi. You've made that point. I'm sure Mr. Berger is ready to reply to it.
Yeah. But there is reference at paragraph 76 of my heads of argument, Milady.
Yeah.
With reference to the case of MEC, Western Cape Department of Social Development, against
paragraph 78.
Paragraph 76.
76, yes.
Yeah, 76 of my heads. And Milady, the SCA said that a claim that a breach or non-compliance with statutory provisions is wrongful and gives rise to delictual liability can rest on either one or of two possible bases.
And that's an SCA case, right?
That's an SCA case.
Okay.
This is, first is where properly construed, the statutory provision imposes an obligation to pay damages for any loss caused by such non-compliance. That involves a consideration of the object of the legislation in order to determine whether, properly interpreted, it imposes an obligation to pay damages if the statutory duty is breached, or provides a basis for inferring that an obligation to pay damages arises at common law. The second is where the breach of or non-compliance with the statutory provision, whether taken together with all other relevant factors, and I skip that, leads to the conclusion in accordance with the common law principles that it was wrongful so as to attract delictual liability. Milady, with reference to the particulars of claim, PFMA sits central to it, breach of those statutory obligations. In fact, the relationship in this instance cannot be more than what the SCA described in this case. And then, Milady, paragraph 85 of the heads of argument. I also made reference to the case of Loureiro and others against Mvula Quality Protection. It's a constitutional court judgment, Milady.
Just please repeat.
Loureiro, it's spelled, Milady.
Yes.
Yes, it's in paragraph 85. Paragraph 85 of my heads.
Oh, yes.
So, Milady, there is no basis to then say that because one part is contractual, the other part cannot be delictual. And I can make reference to this case simply because that intersection between those two branches of the law of obligation was squarely addressed. There is no other basis to see what has happened between the government and Ms. Lehloenya as breach of statutory duty in terms of PFMA.
I've not looked at this judgment, but was there reliance on the Apportionment of Damages Act? Because that could render this case distinguishable. Was there reliance there on the Apportionment of Damages Act?
Well, the case of the last one of the railroad is not about apportionment of damages. It's about the splitting.
There was no reliance. Okay, I'll look at the. Okay.
Yeah. It's about the split to say that something arising from a contract could not give rise to a delictual liability, both in respect of the relationship between the plaintiff and the first and second on the one hand, and between the first defendant and the second defendant. The overriding concern, and I will stop at that point, if I could just address the question of joiner, because I see it's an issue that Milady has raised.
No, you've raised it in your heads of argument, unless you don't want to persist with it.
Milady, I want to persist with it, but to just, if I would not take more time, to say that, Milady, this is a matter where the relationship between joiner and third-party notice in the same group, they are in the same group. We are dealing with SIU that litigates on behalf of the state. At a very basic level, Milady, people have now brought technical objections to saying that we want to recover. The first case said we want to recover from Ms. Lehloenya and Professor Lukele. We then say, this amount you are looking for, we've laid the basis for how the intersection with other liabilities of other people, personal liability, official. Does that impose a positive obligation on the SIU to replicate? On the range of issues that if we're not bringing the Gauteng government into this in a manner, the MEC has not responded to this matter. So what we're saying is that unless this court is satisfied, this tribunal is satisfied on all the conspectors of the evidence, that there is no cause of action whatsoever. And it's a very high order that the first and second third parties, the third party, they have not been able to make that case before this tribunal. The three bases upon which the first and second, the first and second third parties, there's simply no basis for them not to file a plea. If they sit, you cannot defeat a third party notice on the basis that it is simply something of an exception that you have not even been able to clarify, that we then have to go into interpretation. If evidence can be led to support this, and I don't want to read the requirements of exception, the balance favors the tribunal from accepting the third party notice as it is. Unless the tribunal is satisfied that on any conceivable basis, no evidence can, on each of these 5 claims that we have brought before the tribunal, cannot be sustained. And my submission, Milady, is that there is enough in the particulars of claim. There is so much in the amended plea, which has been tightened up by the third party notice, that says that all these possible joint wrongdoers, these concurrent wrongdoers, must all come and answer a claim so that we avoid the multiplicity of action. We cannot defend, who can defend whether the Premier made Circular 3 validly? Nobody except the Premier himself. He has to be a party here. In any event, my conclusion, Milady, is that if Milady would have regard to the capacities in which we have attempted to join the third parties, Milady will see that Claim A basically attacks all of them. And they can choose not to come. We will still have a remedy after we have been able to prove our case. But we cannot defeat it on that basis. Claim 2, Milady, Claim B rather, is also targeting all the 5 third parties. Claim C, it's only against the government parties, and that is vicarious liability. That has been well pleaded. The risk of harm happened, and in my head, I've also made reference to that. I've made submissions on the abuse of power, Milady, and except Milady would want me to address any other issue, that would be all for Ms. Lehloenya for now.
Yeah. I battled with the concept of Gauteng government as cited in the third party notice, who really that is. Notably, the third party notice does not describe who the Gauteng government is. Maybe you can assist me there. And I'm not sure to what extent really, because the pleadings, as I say, they are quite defective. It's a point not taken, but it's quite central to the adjudication of the first ground of exception and the second ground set out in the first in the Rule 13 application. Who really is the Gauteng government?
Milady, the concept of state takes different form.
Yes.
We will just look at the employment contract of Ms. Lehloenya or the HOD or any of these officials. The contract of employment is entered into between Ms. Lehloenya and the government of Gauteng. That is the employer.
So the contract itself says the government of Gauteng.
Well, I will just check, but
the government. Give me the reference.
I'm trying to just confirm. Annexure PO C4 to the particulars of claim, for instance. I just see it said the government of the Republic of South Africa.
Give me the case lines reference, please.
004-58. That's just one instance.
Is it attached to the particulars of claim? Oh, yes. Yes, I've got it here.
004-58.
-58.
Yeah. I just want to check the letter of employment. But I can make that note quickly, but the Gauteng provincial government.
It refers to the government of the Republic of South Africa on page 58.
It does, Milady. I was just trying to get that.
Say the government of Gauteng.
Milady, if we look at paragraph 1.2 of that, it says the employee shall serve the employer in provincial department. And it says National Department, Office of the Premier, Provincial Department, National Provincial.
Sorry, please give me that paragraph again.
Paragraph 1.2.
Yes.
If Milady would give me a minute, I will just check with reference to the public service regulations that the government of Gauteng is actually the employer. And then I may check that.
The contract, the government of the Republic of South Africa is the employer.
This contract, yes. Hence, they are defined as government departments or government components, but I cannot take it further for now.
Yes,
but I can make reference.
If I'm with you on the third party, that the third party notice should be upheld, I need to understand exactly who these third parties are, right? Because in Gauteng, in the Gauteng government, you've got the legislative arm, which consists of the legislature, and then you've got the executive arm, which is headed by the premier in terms of the constitution, right? It's headed by the premier. And then the premier elects members of the executive councils. Those are the MECs. And they had departments. They had different departments. So I need to understand who is the government, because I note in the SIU Act, actually, let me look at it. Section 1 of the SIU Act. So I need to understand if Lehloenya intends joining all the departments in Gauteng, or is it the MECs she's joining? Who is she joining? Because in terms of our constitution, these are independent organs of state, even though they constitute one government. So there's no clarity regarding who's being joined here.
Milady, Section 125 of the Constitution clearly states that the executive authority of a province is vested in the premier of that province.
Yes, as I've stated, right? The premier is the head of the executive, but you are making reference to the Gauteng. You seek the Gauteng. You cited the Gauteng government in your third-party notice, and I don't know who that is. If I'm with you, who exactly am I joining? Am I allowing you to join the premier and his executive, or the whole of all the departments?
There will be no need to join each of the departments in the instance that the premier, in terms of section 125 of the Constitution, as the executive authority for.
Yes, I've got no difficulty with the premier. I've got no difficulty with understanding who the premier is, and the premier is the first third party. My difficulty is with the second third party.
If the premier in his official capacities, then in terms of section 125, responsible for the province, in terms of section 125(1), in all references in the third party notice to the Gauteng provincial government may then as well be just to the premier. So the second third party will then be.
Anyway, perhaps we should leave the point, because the first and second third party don't take the point, so they know who the Gauteng government is.
Yeah, as the court places. But the point, I just don't have the immediate authority, my lady, but it's the president has been sued, the government of the Republic of South Africa has been sued as independent parties. I don't want to take it further, my lady, that we will not lose further if the premier is sued in terms of 125 in his official capacity to take responsibility. Yeah.
Yeah, if I'm with you that the exception must be upheld, they know who it is because they've not taken the point.
Yeah. Melody, just lastly, as accept the special plea, the relief that the first and second, third party will be entitled to, should they succeed on the exception. And that's why the case, by the reference, Melody, to the reference to the case of Pitiladi becomes crucial in terms of when will the court dismiss a third-party notice. Then, if we have regard to the prayers of the first and second, third parties, they're asking for an amendment. That's all they can get. It will not, in this instance, lead to a finality. And the question is whether on every evidence that may be led, any of these third parties will not have something to answer. So my conclusion, my lady, is that the balance favors joining them. If there's no liability on them, they must come and establish it in evidence, not on law, but in evidence. And the submissions around when an exception is upheld to third-party notice are slightly different from even the broader considerations of a party not having, as in the other instances where it's between the plaintiff and the defendant. The third party is a slightly different species that may not be easily defeated on that basis.
Thank you. Mr. Manaiji?
Thank you, my lady. I will deal with first the citation of the first and second, third parties in their official capacity, and just reflect on the kind of answers that have been given, and then deal with the position of the premier.
Check with you if you are okay with working throughout lunch. Sorry, Mr.
Yes, I'm
Manaiji.
okay. I don't know if
I see it's 20 to 2. Can we just finish?
Yes, I'm happy for us to
Mr.
finish.
Berger? Mr. Okurunbi, are you also happy for us to finish?
Thank you, my lady. We're happy to continue.
My lady, I'm equally fine to continue.
Thank you. Thank you.
Thank you, my lady. So I deal first with the position of the first and second third parties in the official capacity. In other words, the debate the court had with Marlene Tren about the provincial government versus the premier in his official capacity. Marlene Tren started by taking the court to paragraph 27 in answer to that. And he said in paragraph 27, we're asking that in the event that the plaintiff is held liable, that one or more of the parties are joint wrongdoers. Alternatively, they are concurrent wrongdoers in the common law and must be, that's also in the event that the first defendant is found to be liable to, as pleaded by the SIU, and continues at 27.3. And the point I made at the outset still remains and hasn't been answered, which is that if the SIU succeeds, in other words, if liability is established against the first defendant, that means she has lost any indemnity that government would have provided for her. She's lost state protection. And once you've lost state protection, you cannot have a claim of any kind by the state, either as a contribution or indemnity towards your liability to the SIU. And
yes, that argument does not address the third party notice to the extent it is addressed to the premier in his personal capacity.
Yes, that's the second point I come to. So I just wanted to deal with that first. It also doesn't address claim B, my lady, because claim B is about a contribution, a reduction. Now, Marlene Tren said you must read section 1 and section 2 together. They deal with different things. I think he's right that they deal with different things, but the problem he has with section 1 is a different problem, because section 1 sub 1 says, where any person suffers damage, which is caused partly by his own fault, so you're the claimant, but partly you've caused the damage, and partly by the fault of another person, a claim in respect of that damage shall not be defeated by reason of the fault of the claimant, but the damage is recoverable in respect thereof shall be reduced by the court to such extent as the court may deem just and equitable, having regard to the degree in which the claimant was at fault in relation to the damage. So a reduction in damages is not a third-party claim. It's to say to the SIU, you are suing in your personal capacity, but in effect, you're occupying the shoes of, you fill in the shoes of government to the extent that government was negligent, that must be reduced.
No, Mr. Munaiti. Remember, the difficulty that I have with Lehloenya's reliance on section 1 is the one raised by Lukele.
Yes,
that's a primary difficulty, right?
That's a primary problem.
But if that difficulty did not exist, I was not with you on this point, because the party who's alleged to have contributed the party who's alleged to be contributory negligent must be before court to answer to that case. The SIU is not that. Is the SIU that party?
No, my lady, I'm raising a different point. What I'm saying is, if the SIU says we want R1 million in damages, and the response is that there was contributory negligence, that is a defense which is raised against the SIU to reduce that claim by the SIU.
Yes, but I'm not with you on that point, because the SIU is not the Department of Health.
No, the SIU would lead the evidence of the department to show that there.
I'm not with you. No. The SIU, and hence at the beginning I raised the point about how the SIU is cited. Forget how the third party is describing the SIU, because this issue has larger implications given the issues that arise in these applications, right? In the exception and in the rule that wait for me to make my point.
Yes,
Mr.
yes, I accept. I'm not interrupting. Yes.
Yeah, I'm not with you on that point. If Lehloenya didn't have the difficulty that arises from the scope of application of the Apportionment of Damages Act, she would have no difficulty persuading me that to the extent that she would like to the extent that she pleads a contribution by any of the government officials. Those government officials, they are independent organs of state. They are individually accountable.
No,
I would have no
section,
difficulty in being persuaded that they should answer to that case of contributory negligence.
no,
And not the SIU.
Respect,
Because the SIU in this case does not take instructions. And that's why it was important for the legislature to empower the SIU to sue in its name and in its right, so that it doesn't take instructions from a government department or the premier or a provincial government or any government official. That's a very important, when you look at the scheme of the act and what it tries to achieve, it's very important for the SIU to have powers to act independently of these organs of state. So they would need to come and answer.
My lady, the point is very simple. Is
Yes.
that Rule 13, and my lady will have regard to the case of Dort and AIMCO.
Yes.
Rule 13 is the gateway for a third-party notice.
Yes.
And your third-party notice is either you seeking a contribution or an indemnity. Section 1 is not a contribution, is a reduction in the damages claimed. And so it's a defense to reduce the amount of damages that you're sued for in order for you to be, for the amount to be, that is held to be a lesser amount. It's not as if government would be indemnifying her or contributing to her liability. It is the claimant's amount that it can get is reduced under subsection 1. That's the point. That's the only point I wanted to make. And my lady, I accept.
But why is the SIU? You see, the SIU doesn't take instructions from government departments.
I'm not saying
right?
it takes instructions.
It's not the SIU case. The SIU is not claiming contributory negligence. It's not the SIU case.
No, my lady, I'm not saying the SIU is asking for is claiming a contributory negligence. I'm saying the SIU says Ms. Lehloenya should pay X amount in damages.
Yes.
Right? And she says, no, that X amount must be reduced because there has been negligence. Your claim, the SIU, must be reduced.
Yeah, but she chooses to make a different case. She's saying, if I'm found to owe 1,000, no, she chooses to make a different case. She's saying, if I'm found to owe 1,000, then as part of the third-party procedure, I would like the liability of these third parties to the extent, in terms of section 2.1, I would like their liability determined so that my liability is reduced by that amount. And hence, I think those officials would have to come and answer, not the SIU.
Yes, my lady, put your finger on the problem. The additional problem is that the claim under Claim B is not a Section 1 claim because it is not SIU reduce the amount. It is to say that if I'm liable, somebody else must pay for the amount to be reduced. And so the answer to that for the government and the premier in their official capacities is still that she has lost state protection. She cannot, by that time, if she's held liable, she would have lost state protection. So, sorry, can I just complete what I'm saying?
Yeah.
So I'm suggesting to my lady that my learned friend's reliance on Section 1 is wrong because Section 1 is not a section where you say, if the liability is 10 Rand, somebody else must pay 5 Rand. The Section 1 is, you, the claimant, your claim must be reduced as against me. And so he's wrong to suggest that he can come home under Section 1, even if he's got problems with Section 2. Because if you read paragraph 28.
Yeah, remember, the Lehloenya carries the burden of duty, right?
Yeah.
To the extent she relies on contributory negligence, she must prove it.
Yes.
Who is she proving it against? Against the SIU? No. Who is she proving that case against?
No, I accept that she would.
Yes, that's why those parties would have to be here. They would have to come and answer, and that's why I've been trying to put to you.
No, I'm not disagreeing with my lady.
Yes.
What I'm saying is that for what she wants to achieve, which is that the department or the province and the premier must contribute to the liability which the court might fix. It's not a case founded on Section 1 of the Apportionment of Damages Act. It is a case under Section 2. So he can't avoid the problems he has under Section 2 by resorting to Section 1. Because Section 1 simply says the claimant's claim must be reduced.
Yeah.
Not
anyway,
somebody must
the preamble, as pointed out on behalf of Lukele, really clarifies the scope of that act. So whether he relies on Section 1 or Section 2, it must be a claim arising in delict. And he's really argued quite extensively why I should find that a claim in delict arises in these circumstances. And I'll look at his submissions. I'll consider his submissions.
But so that's correct. And that's important when you go to the relief, which is 6, which is both in the preamble to the annexure, the notice itself, and in the claim, the relief at 051-27.
Yes.
So the first claim she wants is a contribution or indemnification from one or all of the parties. In terms of Section 1 of the Apportionment of Damages Act. So the first problem is the delict problem. The second problem is the problem I raised, that because she'll only be found liable if she lost state protection, she has no protection or indemnity from the state, as it were. So that aid can't fly on the cause of action that's relied here. The second one is declaration that one or all of them are joint wrongdoers. That's the same problem with the delict issue. And secondly, that the province and the premier in their official capacities cannot be joint wrongdoers in intentional wrongdoing which has lost state protection, because that means she lost the indemnity by the state. Then the third one relates
before
to the
you move to the third one, before you move to the third one, what about her pleaded case in relation to the payments after May 28th?
That at best relates to the premier in his personal capacity, because or is a claim against, at best, against any other official who was responsible for those payments. But her claim for against the government in its official capacity is to say that he is either entitled to a contribution or indemnity, or they are liable for vicarious liability, or they are joint wrongdoers. Yes.
Okay, let me ask you. Let me just clarify. Let me clarify my question to you. My question to you is: let's assume that the SIU succeeds in proving 100% of what is claimed in the particulars of claim.
Yes.
Right. But she wants to institute an action against the third parties. And that action is based on their conduct in allowing the payments after the 28th of May. Just I wasn't there. How could I have continued to commit this crime when I wasn't there?
Yes. Let's assume.
So
but
would she? I mean, the trial court will have to look at up to what point is the loss of state protection applicable. Is it up to the 28th? Because she delineates her case. You know, is it up to the 28th? Is it beyond the 28th? And in the event that it's found to be just up to the 28th, then she surely is entitled to continued state, she's entitled to recover from the other officials for the rest of the claim. Is that not so?
But if the trial court says she lost state liability only up to the 28th, whatever the date is.
Sorry, I should have put it differently. She's only liable up to the 28th.
Yes, if the court says she's only liable up to the 28th, that's the court can then order her to pay for the days after. On what basis would the court do that? Because
okay, and you are saying if she's found liable for the 100%, if she's lost state protection, she's lost it. It doesn't matter how she's delineated her case.
Yes, if the court finds that she's liable for 100% and she lost state protection and therefore she's personally liable, because what the Treasury regulations say is generally you, as an official of government, you have state protection. But if you act in certain ways, you lose that protection and you become personally liable. And if that is the conclusion that the court reaches, then she can't look to the state to make good any part of that claim by the SIU, because to that extent, she's lost any protection by the state. So her claim, her cause of action is a stillborn. There is no cause of action because it's all conditional on her being held liable for the claim by the SIU. But that means that in effect, there is no claim against the state. In other words, in the official capacity. I keep distinguishing it from the premier because there is a claim they make against the premier.
Okay, now as against the premier, in his personal capacity?
Yes, I'm coming to that, but I just wanted to finish the relief because I was at C, where she's asking for vicarious liability for the delicts of the first defendant. Now, again, there's a problem with delicts, but it's vicarious liability. She's saying, even when I've lost state liability, you must hold the province and the premier in their official capacities liable for my delict. But that can't fly because that is the whole point of losing state protection, is that you can't have that protection any longer. So that's and then the D, she says, the first defendant, this is the personal liability of the premier. But the relief, it's important to hear what the relief says, is the first third party is personally liable for the alleged delict of the first defendant. So the first problem is the delict issue. Because although you were read paragraph 33 to 38, which never tell you what the cause of action is, you don't know whether it's under the constitution, under statute, under delict, under contract, you don't know. But you are told in the relief that what they are asking for is for the premier to be personally liable for her delicts. But we know that that cannot be under third-party notice because of the delict issue.
Yeah, the delict issue is really quite a serious issue for Lehloenya here.
Yes, I see my learned friend put his camera on and he's shaking his head. I'm intimidated. But
that's the whole point.
My apologies.
The second problem he has is if he wants the premier in his personal capacity to indemnify the first defendant, then on the cases of Dort and AIMCO that we referred to, there must be an allegation that there is a right to get an indemnity from the premier in his personal capacity. That must arise from contract, from statute, or implied by law. It's not equity, my lady. My learned friend was reading from a 1920s English case, which the court dealt with in AIMCO. But the court then distilled the principles that apply in this country and said it must be in contract, statute, or implied by law. There is no such an allegation in these papers that there is any basis that the premier has an obligation to indemnify the first defendant either in contract or statute or implied by law. Then the last claim is the enrichment claim. You're not told, generally an enrichment claim arises where I've provided value to a third party. Sorry, my lady, it looks like you're frozen unless I'm mistaken. My lady,
Sorry, Mr. Manager.
yes,
The
my
judge will
lady.
rejoin. I just think, yeah, the judge
Okay,
will
we'll rejoin. Thank
just
you.
having difficulties with the connection.
Thank you.
Just
We'll
give her a
wait.
fast.
Thank you.
I'm back.
Thank you, my lady. Yes, yes.
It
So
really welcome. Even the technology is complaining.
yes. So I was dealing with the enrichment claim, which is E. I think my lady had me when I was dealing with the alleged delict and so on in D. I think that there was first, there's a problem with the delict, and secondly, there is no right alleged for any indemnification or contribution by the Premier for her own personal delicts.
I think she's trying to rely on the no profit principle there.
It's difficult to understand what that.
It's not available to her. I mean,
no, she must
obviously the damages are limited to what is proved. That's it.
Yes, correct. And then the last one, which is E, is the enrichment. I was saying that enrichment, the court was quite correct. The enrichment claim would apply to the companies that provided the service, which can say, but you can't claim so much because we provided value and you benefited from that value. The amount must be reduced. But she doesn't say she provided any value which would account for an enrichment claim. So there is just no case made out, no proper allegations. That is our Rule 30 complaint also in relation to the enrichment claim. Now, the mainstay of our learned friends' argument against the Premier is to say, well, we say all the allegations made against the Premier in paragraphs 33 to 38 are about his execution of duties in his official capacity. There's no allegation that he lost state protection, and there is an allegation of a delict. You can't have a contribution or indemnity for that, and there is no right. And also that then he says, well, politicians don't have any state protection. Well, that's not correct, my lady, because and this issue arose in the context of legal fees. My lady will recall the issue with the former president, where he was his legal fees were paid for by the state in a criminal trial, with the understanding that if he is not successful, he would have to repay the amounts. And then that agreement got extended over years and years and years, and the state kept paying. And the EFF and the Democratic Alliance went to the High Court in Pretoria to say that what the president did was in his personal capacity, in his the allegations relating to corruption and resulting in the criminal prosecution were all about conduct in his personal capacity, and the state is not liable for that, and the state attorneys cannot act for him. He's not indemnified for those fees, and both the High Court and the SCA upheld that he should be personally liable for the fees. And the principle underlying that, my lady, is that when an official is acting within his official duties and executing them faithfully, he is indemnified, or she is indemnified by the state if sued because loss was suffered by a third party. But if you act intentionally, wrongfully to cause loss, you lose the indemnity. And under the Treasury regulations, the state must recover from you because you no longer have the indemnity or must sue you. And my lady, the citation in the SCA is Zuma versus Democratic Alliance and Economic Freedom Fighters.
Yes.
And in brackets is case number 1028.
Is it not reported?
The one I'm looking at the neutral citation. It may be reported,
Okay.
but I'm not 100% sure. I'm sure that
Okay.
the High Court one is reported. And I have the citations. If I open an opinion I did previously, I will find the citation. But on this point, because I can find the citation for the High Court judgment. Yes, the High Court judgment is Democratic Alliance versus President of the Republic of South Africa and others, Economic Freedom Fighters versus State Attorney and others, 2019, my lady, Volume 1. Is my lady frozen again? It looks like there might be a connection problem again.
Let me just find out what's wrong.
Yes.
I'm back.
I'm talking to myself for a bit there. I was giving my lady the citation in the High Court. It is Democratic Alliance. Does my lady hear me?
Yes, I can hear you.
Yes, it's Democratic Alliance versus President of the Republic of South Africa and others. Then Economic Freedom Fighters versus State Attorney and others. 2019, Volume 1, All SA 681 GP.
Please
It's a full
repeat,
bench decision.
repeat the citation.
2019,
19,
Volume 1,
1,
All SA
all SA
681 GP.
681 GP.
Yes, and I was just giving the court the citation of the SCA judgment on appeal, and
Oh,
that
yes.
was Zuma versus Democratic Alliance
Yes.
and Economic Freedom Fighters,
Mm-hmm.
in brackets case number 1028
1028
stroke 2019
2019
close bracket and then square bracket 2021
2021
ZASCA
ZASCA
39, and
39
the date of the decision is 13 April 2021.
13 April.
Yes, and the court will find in those judgments a discussion of the reference to the treasury regulations which require the recovery of those monies. So it's wrong to suggest that the treasury regulations on which the SIU are relied do not apply to officials who are also politicians, because they occupy office as the premier under the constitution and also happens to be a politician, but they also benefit from the principle that no one would take up those positions if there was no indemnity, even when you have performed your duties in good faith, but caused loss to a third party. So that's the point. So it doesn't help our learned friends, that principle doesn't assist. So even the claim sought to be introduced against the premier in his personal capacity discloses no cause of action. And we also object to it under the Rule 30 notice. So our submission overall, my lady, and my learned friend has referred to the various paragraphs, various claims under various headings: C for vicarious liability and D for abuse, E for state enrichment. I've addressed them all without going through the various headings. But we submit with great respect to our learned friend that the exception has to be upheld and the Rule 30 objection. And of course, we ask that in the usual order, which is to strike down the Rule 30, but allow them to amend if they can amend. But there are certain issues that can't be amended here. For instance, the
No, it goes
contribution
to the root. I mean, if an exception is taken on the basis that a pleading does not disclose a cause of action, it goes to the root of that action.
Yes. And they can't change that the SIU is not suing in delict, even if they amend. And they can't change the fact that she can only be held liable on the basis that she's lost state protection and therefore can't look
it
to
really
the
goes to the root of the third party.
Absolutely.
The issues raised go to the root.
So
except those dealing with the citation of parties.
Yeah,
the issues, the grounds of exception and irregularity that deal with the cause of action, if those are upheld, they really go through to the root of the third party.
Yes, and we submit that my lady will have every reason to uphold them. And those are
I don't know.
unless those are
I don't know. I must still consider all the submissions and all the authorities that I've been referred to.
That is true. I'm only praying for my friend, my client. That is, as we say now in the notice of motion.
Okay, address me on the non-joinder issue. When I saw it, I wondered whether I'm being gaslighted or whether it's an issue that I should have sleepless nights about.
We don't think you should have sleepless nights about the non-joinder, because the only time the court will raise an issue of non-joinder is if there's a joinder of necessity which has not been effected. In other words, that you cannot carry out the judgment without affecting the rights of a party that is not before the court. But the claim here that is sought against Ms. Lehloenya can be carried out, implemented without adversely affecting the rights of the province or the premier in both their official and personal capacities, and probably also of Professor Lukele. It's a claim directed at her to pay money. So there's no joinder of necessity that arises here, because the other parties would only have be necessary parties if they have a legal interest in the outcome of the litigation, in the sense that the outcome would affect their rights adversely, but it wouldn't. In fact, for the government, it would. If it's positive, it advances. If it's negative, there has been access to court. So there's no joinder of necessity here, my lady, and then the court shouldn't worry about it. Those are our submissions.
Thank you, Mr. Berger.
As the court pleases.
My lady, I know it's late in the day and long in the day, so let me try and be brief. The first point I want to address is to look at the third party notice. My learned friend, Mr. Ogunrumbi, likes to read the notice with some allegations in the annexure, but really if one looks at page 051-2, that tells your ladyship precisely what it is that the first defendant claims in the third party notice. And what she claims against Professor Lukele is only contained in paragraph 1 and paragraph 2 of that notice. The rest, 3, 4, and 5, doesn't concern Professor Lukele at all. One wants a contribution or an indemnification from Professor Lukele as a joint wrongdoer as contemplated in Section 1 of the Act, Apportionment of Damages Act. And 2 asks for a declaration of Professor Lukele as a joint wrongdoer in terms of Section 2 of that Act. So the relief claimed by Ms. Lehloenya in the third party notice against Professor Lukele is based entirely on the Apportionment of Damages Act. Your ladyship has seen from our heads of argument, we've looked at the long title to the Act as well as certain sections in the Act. But and it is so that the indications in the Act are that it applies only in delict. But this issue has been decided by the Supreme Court of Appeal in the Thoroughbred case, which is referred to in our heads of argument. One paragraph in the case that is not quoted in our heads of argument, which I'd also like to commend to your ladyship, is paragraph 13 of the judgment of Murray J.A., Farlam J.A., and Brunt A.J.A., as he then was. It's cited. The case is cited in our heads at 2001, volume 4 SA. The page I'm referring to is at page 600, right at the bottom, because the difficulty is that the paragraphs start from one again in each of the judgments. So you have to make sure you're in the right judgment. It's in the judgment of.
Please give me the name of the case.
The name of the case, my lady, it's cited in our heads, and it is. It's Thoroughbred.
Oh, I've got it. I've got it. Sorry, I thought you were referring to another. I've got it. Thank you.
No. And then I'm just want to go back now to the passage that I was quoting. Sorry. Yes, it's paragraph 13, my lady, of the second judgment. Your ladyship will recall there are 3 judgments in that case. The first judgment and the second judgment came to the conclusion that the Apportionment of Damages Act only applies to claims in delict. Only. There's a minority judgment of one judge, Judge Ulafir, at the end, where he raises doubt. But the decision of the SCA, which is the decision that stands of 4-1, judges saying that the Apportionment of Damages Act only applies to claims in delict. And I wanted to just read from paragraph 13 of the second judgment.
Please don't, Mr. Berger, it is in your heads.
Paragraph 13 is not.
Is it not? Okay.
Paragraph 13, it's the same point which says, the decision of Watermeyer J. and Stein J. in the OK Bazaars case that the Act does not apply to claims in contract has stood for 26 years. This was in 2000. Its correctness has not been challenged in our courts. The legislature has amended the Act on 3 occasions since the decision, and if the decision did indeed frustrate its desire to amend the law of contract, we find it very strange that remedial legislative steps were not taken on any of those 3 occasions. So the point is, my lady, this has been settled in our law for decades, and it continues to be the position of the SCA, and that is that the Act only applies to claims in delict. It does not apply to claims in contract. And in fact, the position at common law in the law of contract is that the law of contract doesn't recognize the concept of contributory negligence. So that is a fundamental difficulty in the way of Ms. Lehloenya, in the manner in which she has framed the relief which she seeks against Professor Lukele. Because the claim, and your ladyship will obviously look at the particulars of claim again, the claim of the plaintiff against both the first defendant and the second defendant is a claim in contract.
Yes, contractual.
Yes. Now,
please deal with the point. Please deal with his point that a delictual duty does arise from breach of
Yes.
contract.
Yes, that's where I'm going now. So our learned friend cites the case of Gaba versus Minister of Safety, which says that the same conduct may give rise to different causes of action. And that's true, because if one looks, for example, at the Lorero case, which was also cited by our learned friend. In that case, it's a decision of the Constitutional Court. In that case, what happened was that there was a security company that had contracted with Mr. Lorero to provide private security to his house. And on a particular night, robbers pitched up, dressed as police, and attempted to gain access to the property. And the security guard on duty allowed them in, and they robbed Mr. Lorero and his family. Now, because there was a contract between Mr. Lorero and the security company, his claim was based in contract. There was no contract between Mrs. Lorero and the rest of the family with the security company. And so therefore, on the same set of facts, their claim was based in delict. So our learned friend is quite right. It's quite possible that you can have on the same set of facts an action in contract or an action in delict. But the difficulty, my lady, with all of that is lily crap. And I must make this point clear. Lily crap has not been overruled. Lily crap has been clarified by the SCA in Holsthausen. And as I quoted to your ladyship earlier from paragraph 10 of Holsthausen, Holsthausen says the distinction is whether the negligence relied on constitutes the breach of a contractual term. In Lillicrap, it did. So what my submission to your ladyship is that in Lillicrap, you had a situation where you have a contractual relationship between the parties. And the negligence that is relied upon constitutes a breach of that contract. In those circumstances, says Lillicrap, you don't have an action in delict. Your action is confined to an action in contract. And Holsthausen confirms that. Holsthausen says where the negligence, because negligence can arise in contract or it can arise in delict, but Holsthausen says where the negligence arises as a result of a breach of contract, then Lillicrap applies, and then that means you don't have a cause of action in delict.
Did you look at the Western Cape judgments that he referred me to?
Yes, I did. And the point is that, and this is how the courts look at the breach of a contractual. I beg your ladyship's pardon. The breach of a statutory obligation. The courts will look at the breach of a statutory obligation and decide whether, looking at the act as a whole and looking at what is required, the courts will decide whether that breach gives rise to a delictual liability. So that's all well and good when you are construing the breach of a statutory duty. But when you have that against the backdrop of a contract which imports those statutory obligations, then the breach of the statute is a breach of a statutory obligation. The breach of the statute is a breach of a contractual obligation, and then it takes you back into Lillicrap. The case that our learned friend, Mr. Ogunrumbi, cites, the MEC case, doesn't detract from the Lillicrap-Holzhausen line of cases.
But isn't that that distinction superficial?
No, it's not superficial. One has to look at what is the relationship between, what is the cause of action between the plaintiff and the defendants, first and second defendant. Mm-hmm. That cause of action, my lady, is in contract. Because of, first of all, it's pleaded in contract. It's not pleaded in delict. But secondly, by virtue of Lillicrap and Holzhausen, it cannot be, the way it's pleaded, it cannot be a cause of action in delict. As a matter of law, it can't be a cause of action in delict, following Lillicrap and Holzhausen. The next question is, does Ms. Lehloenya have a cause of action against Prof. Lukele in delict? And we say our answer to that is she hasn't pleaded the requirements for a cause of action in delict against Prof. Lukele. What is her delictual claim against Prof. Lukele? First of all, in order to answer that question, your ladyship has to look at the third-party notice and Annexure A to the third-party notice, because that sets out the pleading of the third-party claim. So what claim is pleaded in Annexure A, which starts at 051-7? At 051-17, this is paragraph, just waiting for it to refresh. It's paragraph 22.1. She repeats certain paragraphs. Does your ladyship have that?
Yes, I've got it.
This 051-17, paragraph 22.1. She repeats certain paragraphs from the amended plea. So when your ladyship looks at what is the pleaded case, your ladyship must look at Annexure A, but your ladyship must also look at these paragraphs in the first defendant's amended plea. Your ladyship will see that none of the paragraphs pleaded there include paragraphs 20 to 28, which is what our learned friend was going through chapter and verse during his argument. But be that as it may, what she does plead in paragraph 22.1 is she includes 130 to 133 of her amended plea. So if your ladyship would go to the amended plea at 130 to 131, I'll tell your ladyship where you'll find that.
Just give me the page number, I've got it.
It's 130 starts at 030-100.
You look, so I should go to page 100.
Yes, of 030, yes.
Okay.
And in relation to Professor Lukele, she said, what I've managed to identify is, if your ladyship looks at 131, which starts at page 102.
Yes.
She says in 131.2, the second defendant and or Arnold Malotana and or Ms. Tandi Pino and or others. She says approved payments in certain circumstances. Your ladyship will read all of that. And acted negligent, the last one, 131.2.6, acted negligently and unlawfully in so doing. So there's an allegation that Professor Lukele approved payments when he was aware that the payments had been stopped, and in so doing he acted negligently and unlawfully. In 131.3.2, this is at 104, she says that they were under a duty to stop the payments to Ledla and or Bidika. And then finally, in 131.3.3, she says there that the Premier and or the provincial government and or the second offendant negligently and in breach of the PFMA and the Treasury regulations failed to stop payments to Ledla and or Biadika. But, my lady, I'm going to ask your ladyship to just have a look at 132.8 and 132.9. And that your ladyship will find at 030-110. Where she makes these allegations. So your ladyship will recall there's allegations of negligence against Prof. Lukele and that he acted unlawfully. And then she says at 132.8, she says the negligence of the Premier of the Gauteng province is the proximate cause of the payments to Ledla and Biadika after the 6th of April, alternatively the 28th of May. And 132.9, the alleged losses forming claims A and B of the particulars of claim were the natural and direct consequence of the proximate cause, without which the alleged wrongful acts and losses would not have occurred. So the pleaded case, my lady, is that Prof. Lukele was negligent, but that the proximate cause of the payments and the proximate cause of the loss is the Premier of Gauteng. So the allegations of negligence against Prof. Lukele hang in the air. There is no claim pleaded against Prof. Lukele which satisfies all the requirements of a delict, because he's not the cause of the loss. The cause of the loss, she says, is the Premier. And this concept of negligence hanging in the air is well known to our law, my lady. It doesn't attract liability. Your ladyship asked our learned friend several times to identify the cause of action against Prof. Lukele. And our learned friend jumped around a lot, but with respect, never identified for your ladyship the elements of a cause of action in delict by the first offendant against the second offendant. And there is none that is pleaded. My lady, on the issue of the indemnity or the contribution and the inability of the first offendant, Ms. Lehloenya, to identify a contractual term, a statutory term, an implication of law, we align ourselves with the argument from our learned friend, Mr. Maineche. I'm not going to repeat the submissions that he made. Those cases are direct authority for the proposition that unless you can rely on a contract, a statute, or an implication of law, you're not entitled to claim a contribution or an indemnification. My lady, I'm not sure if your ladyship wants to ask me about the joinder point.
Do you have a different point to make?
On joinder.
Yes, from the one made by Mr. Manager.
It's really a point that should have been answered by the SIU. One wonders why the SIU hasn't joined those parties to this litigation. But the submission.
But he raises a different point. He says I should have sleepless nights when a defendant before me makes the allegations against the Premier of the province as well as his government. They should be here to answer on those allegations, given their constitutional duty to account in how they have exercised their functions when one has regard to the scheme of the legislation of the SIU Act.
I'm not going to make submissions against that, my lady. So, my lady, as far as the third party notice against Prof. Lukele is concerned, Prof. Lukele is present as a second defendant. He will have to answer for the claim against him in relation to his liability and responsibility for the losses. And if there's no causal link between his conduct and the losses of the department, then he will not be liable. The same goes for Ms. Lehloenya. If she was not responsible or present when certain payments were made, then she will not be held liable for those payments. So
that's for the SIU to prove, right? For the SIU.
That is for the SIU to prove, and the SIU also has to prove that both Ms. Lehloenya and Prof. Lukele have forfeited the protection that they're entitled to, and that will be an argument in due course. But Prof. Lukele is present before your ladyship. Ms. Lehloenya.
The purpose of accounting. You're saying for the purpose of accounting, he's here. There's no need for him to be joined again as a third party, because the SIU case against him seeks to achieve exactly that. And
in addition, there's no basis for Ms. Lehloenya to seek a contribution or an indemnification from Prof. Lukele. Thank you, my lady. Those are our submissions.
Thank you. It's been a very, very long day, but I did anticipate that we'll be here the whole day. I'm glad we don't have to use tomorrow and start looking at the. Thank you very much for your assistance. I know that I truncated the time frames, particularly that are applicable in a Rule 30 application, to get us here so that at least this week is not completely wasted. I am, however, concerned about the delay in getting to the trial heard, because the third-party procedure, has occasioned that the trial was supposed to have commenced this week. Now we have a second set of dates coming up in October. I think, is it October or late September?
It's October, Melanie.
It's in October. Now, in the event that the third-party notice is not upheld, I would like us to have a case management meeting as soon as possible and look at the prospects of having the trial commence on the second set of dates that we've agreed upon. So Mpho will get in touch with you to arrange dates. If you could avail yourselves as soon as possible, because time is of the essence. This is a huge matter. And some of the parties, particularly Ms. Lehloenya, is behind with complying with some of the directives. So there's quite a lot of work to be done if the trial is going to commence on that date in the event that the third party notice is not upheld. So please avail yourself early next week. Mpho will get in touch with you to arrange the date.
Thank you, my lady.
Please. Thank you.
Thank you. Thank you very much. The proceedings are adjourned.
Thanks,
Thank you. Thank you.
That's what I'm saying.